Hi, thank you for joining me. I'm Jaime Christine Brown, and this is my Week 4 assignment for Internet Law and Legal Issues, presented to Dr. Robert Perillo. For this week's assignment, I'm doing a presentation for El Grappo of Priceline.com via live stream video. In the presentation, we will be outlining some of the major issues involved in terms and condition clauses found on websites. One thing that we will be discussing is the e-Sign Act, which protects the users who have not agreed to certain terms and conditions found on websites. So let's get started.
Hotel in Chicago? I'm on it. Got a guy, needs a deal on a room.
It's $200 a night.
Most of us are quite familiar with Priceline.com and their website, offering Priceline negotiations throughout the world on travel deals for hotel accommodations, airfare, and car rentals. What you don't realize is that once you've viewed their website, you are assumed automatically to have accepted their terms and conditions, which deems Priceline.com not liable for anything that happens to you throughout your travels or on their website. They have taken away all liability from themselves in an assumption notion that you have accepted their terms and conditions. So we are going to be calling via live video right now El Grappo, and I'm your host, Jaime Christine Brown. Good day, Mr. El Grappo. It's a pleasure to be here with you today. I'm Jaime Christine Brown, CEO of Jaime Christine Brown Internet Marketing. I've gone over the terms and conditions clause found on your website at Priceline.com, and I've outlined a few details and recommendations for your website. I've also outlined a couple of details about the e-Sign Act, which I think you should take into consideration as well. So, let's get started on the presentation. To get started, let's discuss your concerns and the issues that you may have with your terms and conditions clause on Priceline.com. The first area of concern was whether or not it is a valid contract, and the second area of concern is that whether or not a user should click an I agree button or icon or something similar to that. We also need to discuss what the user's obligations are and what Priceline's obligations are and what are unenforceable statements in the agreement and why the company would have those statements in the contract if they were actually not enforceable. As you have requested, I took into careful consideration to read the terms and conditions and go over it in great detail to make sure what you are actually stating you are obligated for in your terms and conditions clause on your website. And thus far, I only see two obligations that you have stated to the users on your site at this point. So let's just go ahead and review the two obligations that you're currently stating on the site right now. The first obligation found on your terms and conditions policy is in the area of pricing errors. Priceline.com is promising users to give them a refund promptly on their credit cards if their request was canceled and their card was already charged. This is one of the most important obligations that Priceline.com states on the terms and conditions on the Priceline.com website. Concerning the rest of the terms and conditions, you're stating in the terms and conditions policy that Priceline.com is not liable for anything. And then at the bottom of the terms and conditions, you say that you know that it's not a valid contract, but you want to stay out of court. Why would you even put something like this on your website? I think that that statement definitely needs to be removed from your terms and conditions. And we need to make some adjustments on your terms and conditions so that way you don't look like a laughing stock. I believe the main problem with your terms and conditions is that it's not really actually an agreement per se, not legally anyway. You can't actually have someone agree to something that they haven't even read or accepted. There's proper ways to do things, and in order to actually make the contract legally and binding, we have to go according to the law and the rules and the regulations. One thing that I think will help you in getting to actually get the users and validate the fact that they have agreed to the contract would be to go ahead and implement the e-sign act. And I think this would protect you and the users as well. So this is something that I feel that we definitely need to start implementing on your terms and conditions clause immediately. Mr. El Grapo, since I'm sure you are very much aware that your contract is not valid, and since you've stated it in the terms and conditions prior to me looking at them, I'm sure you are very well aware that the contract is not valid. So let's get into how we can validate this contract with the users and actually hold the users liable for what's in the terms and condition clause on your website. Mr. El Grapo, I'm not sure if you are aware of the e-sign act or not. The e-sign act stands for Electronic Signatures in Global and National Commerce Act. The e-sign act has been enforced since June 30th of 2000, and it is a basic guideline for the use of electronic contract formulation, signatures, and record keeping in private commerce by establishing legal equivalence between contracts written on paper and contracts in electric form, pen and ink signatures and electronic signatures, and other legally required written documents termed records, and the same information in electronic form. The e-sign applies broadly to commercial, consumer, and business transactions affecting interstate or foreign commerce, and to transactions required both by federal and state government. If there is in no writing required by law, e-sign does not apply. Sadly, the only thing that I see that is actually enforceable on your terms and conditions at this point is the copyright notice and the trademark notice. Those are actually not even in the area of terms and conditions, but those are the only things that you can actually legally enforce at this point in your terms and conditions clause on your website. For your protection and the protection of your users, it really does matter whether the user has read the contract or signed the contract by using e-sign or some other verification method. Your contract is not going to be valid or hold up in a court of law unless you take these best practices on and implement them on your website. So this is very important for you to do at this time. And it does matter. This is one of the most important things that people need to realize. Just because you post it doesn't mean that people actually have agreed to it. If they haven't signed it, they don't know what it says, and they can argue that point in court. So the best protection is to go ahead and actually implement the e-signed act and actually have them agree and accept your terms and use and conditions on your website, and that way you will be protected in a court of law. Let's go over the steps of implementing the e-sign act on your terms and conditions policy on your website. First, we will ask the users to agree to the terms and conditions. Then we will ask them to verify that they have read the terms and conditions. Then you ask them to accept the terms and conditions on your website. Additionally, you will add an option for them to not accept the terms and conditions. Then it is very much recommended that you add an option so that the user can print the document and keep it for their records. In this segment of the presentation, I would like to review the ways that we can implement the e-sign act and also the recommendations that I have set forth for your terms and conditions. The recommended changes I propose for your terms and conditions policy on your website at Priceline.com would be, first of all, to implement the e-sign act, give appeal to the users, let's simplify the terminology on the terms and conditions, and then let's omit the no liability clause, like you already know you're liable but you don't want to go to court clause. And then lastly, let's give the user the option to print the terms and conditions document out for their records. Those are my recommendations for you. Mr. Aguapo, this concludes my presentation for you, and I hope you enjoyed it. If you have any questions or you need any more information, please contact me immediately. I'm here for you anytime. Thank you so much for your business, and it's such a pleasure to work with you. Thank you so much.